Guilty. That is the verdict against Michael Jackson's former doctor, Conrad Murray.
We, the jury in the above entitled action, find the defendant, Conrad Robert Murray, guilty of the crime of involuntary manslaughter in violation of Penal Code Section 192, subsection B.
Murray showing little reaction to the jury's decision. Members of Jackson's family, including his sister LaToya, wept quietly after the verdict was read. Murray was handcuffed almost immediately and is being held without bail until his sentencing on November 29th. Now, he could get 4 years in jail and he could lose his medical license. Joining me now is Robert Schalk, criminal defense and civil attorney at the law firm of Collins, McDonald & Gann, which is based in Mineola. Robert is also a former Nassau County assistant district attorney. I appreciate you coming here and giving us your legal thoughts on this trial. All right, we know what the verdict is. Let's set that aside. Which side, the prosecution or the defense, just had a better trial?
The prosecution definitely tried a better trial. They had a lot of evidence working in their favor. I think most importantly, they had a doctor who had given up his practice in Houston and Las Vegas to specifically work for Michael Jackson, making $150,000 a month. Although he never got the money, that was what the contract was for.
Right.
You also have a situation where that fateful day when Michael Jackson died, the doctor's first reaction, call 911? No. He starts covering up evidence, starts covering himself, because he obviously, that consciousness of guilt on his account that he was doing something wrong.
Yeah, and a lot of people were actually, calling for blood of Dr. Murray. I mean, they really wanted him to almost get the death penalty for this. And the prosecution, they didn't go that far. I mean, they didn't this wasn't a Casey Anthony trial where he's suddenly seeking the death penalty and he couldn't even have a cause of death.
Exactly. That's a great point, because in Casey Anthony, I think one of the major reasons she was acquitted of all those charges is because it was an overreach by the prosecution, charging her with murder in the first degree when you didn't know a cause of death, when you couldn't prove premeditation. Although it's questionable on whether or not this case should ever have been brought in a criminal court, the DA's office did a great job of establishing this is what we can prove with these facts. It's the lowest level homicide offense. It's only punishable by up to 4 years in jail. Now that may seem like a lot to some people, but he wasn't charged with murder. He wasn't facing life in prison. Right. The DA's office was very calculated in what they charged here. It took them 8 months to bring the charges against the doctor.
Right, involuntary manslaughter, it's something to point out that they only have to prove this recklessness from the doctor, right?
Correct. The gross negligence, this gross deviation from the standard of care, that the doctor didn't have any emergency medical equipment in the room, because it wasn't illegal for the doctor to administer these drugs to Michael Jackson. That's California law. It's not illegal to do it. They're saying that he grossly deviated from the standard of care that a normal doctor would give a patient in a hospital or a therapeutic setting. He's at his home.
In a bedroom.
Correct. In a bedroom, giving him high doses of narcotics that you would only see in an operating room.
Right. Even the prosecution got the defense's expert to say, I would never do that in a bedroom.
Which is killer for the defense. I mean, the defense didn't have a good 49 days of trial here. I'm sorry, 22 days of trial here with the 49 witnesses. They changed their defense in the middle of the case, which was crippling for them.
Right. As a criminal defense attorney, I mean, you look at that and what does that tell you?
As a criminal defense attorney, you have no legal obligation, no burden of proof whatsoever to prove anything in a case. You could sit there and play cards with your client and not question a witness. But as a defense attorney, the minute you start putting on a case, the minute you start calling witnesses on your client's behalf, stick to the story. It's one story, and that's the defense the whole way through. To change in the middle of a trial, if the jury can't make heads or tails of it, how are they going to rule in your favor?
Right. Let's talk about, I mean, he could have gotten probation, or he hasn't been sentenced yet. He can get probation up to 4 years in jail, and under California law, he can serve that in a county jail. We know the overcrowding situation with certain celebrities that go in and out of jail like a revolving door. What does it tell you that he remanded him without any bail pending sentencing? What does that tell you?
I think he's going to give him, we're not talking a minimal period of incarceration here. The judge has no reason to remand him if he was going to give him a short stay. I think it's an indication of he may give him the maximum period of incarceration. That's what I've seen both as a defense attorney and as a prosecutor, that when you're dealing with a homicide and you're dealing with a remand situation where he can't bail out, whether he had $10 million, that the judge is sending a sign and a signal to the defense team that he's going to do some serious jail time here.
Well, let's talk about the jury, because I find that very interesting. 7 men, 5 women, 9 of them previous jury experience, 3 of them have addiction problem in their past, and one, you were telling me that one actually almost got conflicted out because
Yeah, there was one juror that I think was a videographer of some sorts that actually had done previous work on a Captain Neo video or movie that Michael Jackson had done out there in California. How the defense team even lets this person on the jury is befuddling. I mean, jury selection is the most important time in a criminal case, and to allow people, even people who've served on a jury before, as a defense attorney, I would want people who are fresh, who've never been in a room deliberating, because they don't have predisposed assumptions as to how it's supposed to work, whether they've convicted somebody before. I would want someone to come in there with a clean slate who's never been a juror before in a case like this.
All right, we'll see what the judge does. November 29th, Tuesday, November 29th is when he will be sentenced. So I appreciate you taking your time, Bob Schalk, coming in and giving us your thoughts.
Thank you so much.
All right.